Afternoon, everyone. I'm Judge Corey Amanda Cotham. We're here for the afternoon session of first appearances. I will begin by going through our first appearance docket, and then we will move to the hearing docket. Just a reminder to everyone that everything we say is being recorded and can be used against you at a later date. So I encourage you to speak with your attorneys before speaking on the record today. Before we get started with the stack, I do have a couple of people that are signed in. If I have him present on page 4 of the second look docket, Duncan Mitchell, his private counsel, Mr. Lewis, is present. Do we know which facility he's at, Mr. Lewis?
I see him coming up. It looks like he's in the main jail.
Judge, there's your private attorney, sir.
Thank you, Mr. Romero. Good afternoon, Mr. Mitchell.
Good, how you doing?
I'm good. So, Mr. Mitchell, let me just get you on my docket here.
Judge, good morning. Jim Lewis on behalf of Mr. Mitchell. Judge, I've spoken to the prosecutor in the case. He does have a SOR violation out of Palm Beach County. At this point, we're trying to get him directly into a rehab. So, quite frankly, I'd just like to leave status quo where we are right now. I'm going to be going up to Palm Beach next week and see if I can convince the judge up there to let him go directly from jail to a rehab.
Okay.
So, respectfully, we're not asking the court to take any action today.
Okay. All right. In light of that, I will leave the bond in place as is. I believe it's set at $1,000 currently.
Yes, ma'am.
So we will leave that in place at this time.
Thank you, Judge.
All right. Thank you very much. Yes, it's Mitchell Duncan. All right. I also have someone signed in on Joshua Perez. He's on page 7.
7 exactly. Judge, he is here present. He declined the service of public defender. He advises he has Mr. Kevin Kulik. Come on up there. Right.
I'm sorry, Mr. Romero, are you saying that's his private counsel?
Mr. Perez, yes, he said he hired Mr. Kevin Kulik.
Okay, he has I'm sorry, ma'am, you can just come to the podium. He has a family member present who is advising that Mr. Kulik has not yet been retained. So I'm not sure
Mr. Perez told me different.
Not sure if he wants to rethink that decision or not.
Yes, because I have a couple attorneys I have called.
Okay, ma'am, are you a relative?
His fiance.
Okay. All right.
Judge, if we could put that on brief recall, he changed his mind, he wishes to apply for public defender.
Okay, I thought that might be the case. All right, I'll just put him to the side. Let me know when he's ready to proceed. All right, so next will be Sharon Caruana.
North Broward.
Thank you.
Right.
Good afternoon, Ms. Caruana.
Yes, hi.
You are before the court this afternoon on 2 counts. Count 1 is for disorderly intoxication in a public place causing a disturbance. Count 2, Ms. Caruana, please. 1 moment, please.
Okay.
Count 2 is for resisting an officer or obstructing without violence.
Oh my God.
I find probable cause for these charges, and I will hear from the attorneys.
Judge, in speaking to Ms. Caruana, at this point she does not have any money in her possession, in her property, or any way of bonding herself out. She was residing in that hotel because she was living with her son who was unable to pay the mortgage. They were evicted, so she's sort of fallen upon hard times. I don't believe she has much in the way of priors, and on this case, in reading the PC, I was going to ask the court to consider that and ROR her. With a no return, I mean, she won't go back to that hotel. I've spoken to her about that.
Yeah.
Based on our conversation, Ms. Caruana was able to obtain information as to where Ms. Caruana is actually going to be staying, if she's not going to be staying at the La Quinta.
Speaking to her, she agreed not to stay there. Based on reading the PC, I assume that wouldn't be the case. She would be going to another hotel at this point. That's why I'm asking for ROR, but she can review. I did talk to her about a future court date, but that's what she had indicated to me.
Do you have anything else? All right, Ms. Caruana, I'm going to ROR you on count 2. That means that you will be released today. You need to
Thank you.
you need to understand, as I'm sure your attorney, Ms. Chase, has explained to you, that though you are going to be released today, that does not mean that that's the end of the case. So that means it will be your responsibility to follow up with your attorneys and the clerk's office to monitor any future court dates.
Do I need an attorney?
You have a public defender present. Let me just ask, Ms.
Oh.
Chase, is there perhaps another issue that is not before me today that I need to be aware of?
I'm not sure. I don't believe so. I mean, at this point, normally we would send someone to the jail. I know we're appointed for today's purposes, but I'll talk to her as far as what we can do to keep track of her case and her getting in touch with our office. I can call her back.
Ms. Caruana, what I want you to understand is that I know that you don't have a permanent address right now. That means that you're probably not going to be receiving notice of your future court dates, which is why it is so important for you to keep in contact with your attorneys, which are through the public defender's office, and with the clerk's office, so that you know about any future court dates that you have to be present for. Because if you miss a court date, then the judge can issue a warrant for your arrest. Do you understand that?
Yes, I do.
All right. There's also going to be an order of no return, which means that you are not to return to the hotel where this
never
alleged
know that.
incident occurred at. All right. You understand that?
100%.
Okay. All right, Ms. Caruana. Good luck to you.
Thank you.
You're welcome. Nicola Miller. Thank you. All right. Good afternoon, Ms. Miller.
Hi, how are you, Yana?
I'm good, thank you. Ms. Miller, you're before the court on a traffic capias. This relates to a charge for operating without a valid license. I find probable cause, and I will hear from the parties.
One moment, Judge.
Thank you.
Judge, sorry about that. I was trying to get additional information, Ms. Miller. What I was going to be asking the court, my understanding is she missed court back in 2018. My understanding, when initially she came to court, she was confused. She thought if she were able to try and, she had other issues going on in Dade County, if she was able to try and fix those situations, she wouldn't have to come back to court. I believe that's what led to the confusion. I told her, no, there's still a case. She will be coming back to court, Judge. She is a single mother raising her 12-year-old daughter. Right now, her daughter's with her grandmother, with her mom, but she really wants to be there for her. She can't afford to post any sort of monetary bond. I'm asking on this operating without a valid license, the 2018 case, the court would consider releasing ROR on the alternative in the pretrial release.
First off, if this was her first time in this, having a case in the system, I might understand that, but she's had felonies and misdemeanors. She pled a DWS habitual offender as a misdemeanor in 2014. She knows taking care of your driver's license in another county doesn't end a criminal case in Broward. Additionally, as far as not showing up, she was present and was given court notice September 12, 2018 at her arraignment, and was, it's clear on the appearance, to be present on December 5th, 2018 at 10:30 a.m. And now here we are over a year later. I'm trying to avoid another year wait.
It's provided to her in court, is that what you're saying?
Yes, she was given the notice in open court.
And Judge, at this time, we're not denying that she received something in court. It was just honest confusion. maybe because of what Mr. Lunder said as far as her priors, maybe ROR wouldn't be the solution. However, but because I believe Ms. Miller's being sincere, I'm asking then for her to be released on pretrial release. She'll still be under supervision. She'll still have to come to court. This is a 2018 case. That's what I believe my request is reasonable, Judge.
Does she have any other failures to appear?
License was suspended in Broward February 4th of last year because she failed to appear in court. January 3rd of last year all as well.
2019 cases?
2019 traffic matters, yes. She's got a lot more prior cases in Dade and Broward. Ms. Miller she's had enough cases that she really should be familiar with how the system works to think that she just didn't have to keep coming to court because she took care of her license and never went back to court in Broward.
All right, I'm going to leave the standard bond in place at this time. Ritzaline Hilaire.
Ms. Hilaire is here, present, Judge.
Thank you. Good afternoon, Ms. Hilaire. Ms. Hilaire, you're before the court this afternoon on one count of grand theft greater than $750, less than $5,000. I find probable cause, and I will hear from the parties.
Judge, speaking Mr. Hilaire, my understanding, and I'm sure the state's going to correct me if I'm incorrect, this is her first time being arrested. She's a registered voter in our community. She's been living here since 2006. She's 22 years old. She's a graduate of Miami Edison High School class of 2014. Right now, she's not working. I'm assuming she's no longer employed by Walmart. But having said that, Judge, she lives in North Miami Beach. She will be coming back to court. So I'm asking, considering this a nonviolent offense, I'm asking if the court consider releasing her straight ROR.
It's fine, Judge.
All right. I'll grant the request. Count one will be an ROR. There will also be a no return order to the Walmart where this incident allegedly occurred at. Ms. Hilaire, a couple of things for you to know. Number one, though you are being ROR'd and you're going to be released today, that does not mean that that's the end of this case. That means it will be your responsibility to follow up with your attorneys in the clerk's office so that you know about any future court dates that you have to be present for. Do you understand that?
Yes, Your Honor.
All right. Additionally, there's going to be a no return order, and as I said, you are not to return to this specific Walmart. Do you understand that?
Yes, ma'am.
All right. Thank you very much. Cody Tigner. Thank you.
Bonded, Judge.
Thank you. For the record, I find probable cause. Thayer Malky.
Mr. Malky, come on up, please.
Good afternoon, Mr. Malky.
Good afternoon.
Mr. Malky, you are before the court on one count of trespassing or failing to leave property upon order by owner. I find probable cause, and I'll hear from the parties.
Judge, my understanding, Mr. Malky, has a record. I'm seeing if this state hopefully doesn't have any straight ROR. Someone's microphone
I'm
is
not,
on.
one of the other facilities has a mic on. If you could turn that off, please.
I'm fine with an ROR, just with an order not to return.
All right, Mr. Malky, I'm going to grant the request and ROR you on this count. You probably heard me say this already, but I'm going to say it again. Though you're going to be released today, ROR, that does not mean that that's the end of this case, which means it will be your responsibility to follow up with your attorneys in the clerk's office so that you know about any future court dates that you have to be present for. Do you understand that?
Yes.
All right. Additionally, there will be an order of no return. That should go without saying because based on what I'm seeing, there's already a trespass warning or at least a ban of some sort in place with regard to this property. So you are not to return to this property. Do you understand that?
Yes.
All right, thank you. Harrington Carter.
Mr. Carter's here, main judge approaching. Come on up, Mr. Carter.
Good afternoon, Mr. Carter.
Good afternoon.
Mr. Carter, you're before the court on a traffic capias. This was for unlawful use or display. I find probable cause, and I'll hear from the parties.
Judge, as you can see, this is 2007 offense. He's asking if the state has a plea offer in order to resolve this case today.
Holding court cost.
Withholding court costs?
Judge, he wishes to accept the state's offer.
All right, thank you. Mr. Carter, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. And Mr. Carter, do you understand everything that's been discussed here so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Carter, what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. And once again, your sentence will be a withhold of adjudication plus court costs. Good luck to you. I'm going to take a very brief recess. One moment. Next up will be Solomon Shiver.
He's here present, Judge Amin.
Thank you. Good afternoon, Mr. Shiver.
Hello.
Mr. Shiver, you're before the court on count 1, distributing or delivering cocaine. Count 2, using a two-way communication device to facilitate a felony. Count 3, delivery of counterfeit substance. Counts 4, 5, and 6 are each felony probation violations with no bond holds. I see that you will be having a hearing before your division judge on Monday to address the VOPs. I find probable cause. Do the parties wish to be heard on counts 1, 2, or 3?
Judge, considering he has no bond holds, he has to seek, basically go in front of his division judge to seek some sort of relief and nothing to add from the defense.
All right. Then the standard bonds will remain in place. Thank you. Lazaro de Banos Abali.
He's here present, Judge Amin. Come on up, Mr. DeBanos.
Good afternoon, Mr. DeBanos.
Good afternoon.
Mr. DeBanos, you are before the court on counts 1 and 2 are for fraud, use, or possession of identification of another person without consent. Count 3, possessing, receiving, or retaining a stolen credit or debit card. Count 4, possession of methamphetamine. Count 5, possession or use of drug paraphernalia. Counts 6 and 7 are for possessing a blank, fictitious, or unlawfully issued driver's license. I find probable cause for these charges, and I will hear from the parties.
Judge, if my math is correct, I believe he currently has a bond of $6,100. And speaking of Mr. DeBanos, unfortunately, he's not in a position to post that monetary bond. nor his family. Now, he's been here almost half of his life. He's 31 years old. He's been living in our community specifically 15 years. He's self-employed. He's a plumber by trade. He's been doing that for about 3 years. From what he advised me, business isn't good. He made about $500 just last month. Now, he lives in Miami in a trailer with his father. They've been living there for the past 5 years, so he does have very strong ties to South Florida. Unfortunately, his father's not working. His father's not going to be able to afford to post any sort of monetary bond. So Mr. DeBanos is requesting on these non-violent offenses for the court to consider releasing him on pretrial release.
Your Honor, I don't believe Mr. DeBanos Abali is a good candidate for pretrial, just considering the nature of the allegations that he was found to be in possession of 2 different Florida driver's licenses belonging to other people, 2 Social Security cards, a Home Depot credit card, and it was verified that all of those cards were stolen during a vehicle burglary. Also noting his criminal history, 2019 date false name ID after arrest, 2019 out of date resisting without violence, DWS third or subsequent offense, 2019 out of date. Possession of cannabis with intent to sell or deliver. 2017, possession of cocaine with intent to sell or deliver. 2017, grand theft auto. 2016, threatening a public servant, resisting without violence.
Does he have any failures to appear in his history?
Oh, sorry.
Your Honor, all of his priors are out of date, so I don't know. But I can tell you that I'm showing there's 5 felony convictions, 3 misdemeanor convictions, 43 prior cases where no disposition has been reported.
Mr. Mayor, did you have something else you wanted to add?
Judge, just one little piece of information. To be candid with the court, I haven't had an opportunity to read the PC affidavit. However, my understanding is, I believe the merchandise was found in a vehicle in which Mr. DeBanos was the passenger. So that's the only additional piece of information I have, Judge.
To release Mr. DeBanos to pretrial supervision, but he will be subjected to random testing, which means no alcohol, no intoxicants. Mr. DeBanos, a couple of things for you to know. Your attorney is going to be giving you some information about pretrial supervision. You must report to pretrial supervision by Monday. If you fail to report to them as I have instructed you, then a warrant will be issued for your arrest. Do you understand that?
I understand that.
Additionally, you are going to be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants. Do you understand that?
I understand that.
All right, thank you.
And Judge, whenever the court's ready, we're ready to proceed on Mr., I think, Joshua Perez.
All right, thank you. All right, I believe that Mr. Perez is on. Good afternoon, Mr. Perez.
Hello.
Mr. Perez, you are before the court this afternoon on count 1, aggravated battery on an officer. Count 2, resisting an officer or obstructing with violence. Count 3, resisting an officer or obstructing without violence. Count 4, aggravated fleeing with injury or damage. Count 5, fleeing or eluding law enforcement while lights and sirens are active. Count 6, fleeing or attempting to elude law enforcement. Count 7, leaving the scene of a crash involving damage to property. I find probable cause, and I will first hear from the parties.
Mr. Perez, to put it plainly, reading this report and this history, he is a danger to the community. Count 1, aggravated battery on a law enforcement officer, first-degree felony, intentionally driving his vehicle at a law enforcement officer's vehicle. The officer had to jump into the vehicle to avoid being struck, and his vehicle was still struck by Mr. Perez's requesting a $25,000 bond. The resisting with violence, $1,000. Aggravated fleeing with injury or damage. Noting this was a significant incident, flight from law enforcement. The officer, or I guess deputy, mentions that Perez led officers and deputies through multiple jurisdictions throughout Broward County. I would also note he was arrested at 12:34. This is in the middle of the day, late morning. I imagine there were plenty of drivers out on the road while this was going on, and their safety was certainly potentially put at risk. And I would also note, Your Honor, and this is mentioned in his co-arrestee's report, Moses Jumper, that while this is all going on, there was an AR-15 rifle in that vehicle. Your Honor, I'm going to request a $10,000 bond on count 4, pretrial release of the GPS monitor level 1, no driving until further order of the court. The court should also be aware, last year, Mr. Perez had a theft. He was placed on 3 months probation on July 31st. Prior to that, in 2010, he was convicted of burglary of a dwelling with a battery, burglary of a dwelling, attempted burglary of a dwelling, felony battery against a victim over the age of 65 years of age, and petty theft. He was sentenced to 80.5 months state prison as a habitual offender. He also had in 2011 possession of alprazolam and oxycodone. He received the same sentence to run concurrent. He was just released from state prison in 2016 on those cases. Additional priors include 2007, possession of cocaine, oxycodone, carry and concealed weapon. He violated probation in that case. 05, unlawful use of false name ID. 04, DUI. 02, burglary of a conveyance. He violated probation. Nothing further, Judge.
Mr. Romero?
One moment, Judge. Judge, in speaking with Mr. Perez, right now he's in the process of applying for disability. So from what he advised me, he's okay with the supervision request that the state has asked for. What unfortunately he believes is going to present a problem is the monetary amount which they're requesting. Now we're okay with count 2, their suggestion as far as $1,000. What I was going to be asking the court to consider is on count 1, a $5,000 bond, and on count 4, a $5,000 bond, which would be a total of $11,000 for those 3 offenses. Now, in speaking with Mr. Perez, Judge, he's residing here in Broward County his whole life. He's 36 years old. Before he was applying for disability, he was a painter. He was doing odd jobs as well. I believe the last time he was paid for a painting job was about $500 that he made. So, Judge, as you can see, his funds are very, very limited. Now, he appreciates his girlfriend being here for support. My understanding, Judge, is she's the one that's going to be able to help him. Will be helping him post his monetary bond, but unfortunately, she's a dog groomer, so her financial resources are limited. Now, they rent, they do not own, and I believe their monthly rent is somewhere in the neighborhood of $800. So as you can see by their expenses, they're not going to be able to afford what the state is asking for just on those 2 counts, $35,000. So at this time, that's why we're requesting a $5,000 on 1, $1,000 on 2, $5,000 on 4, and a photo order so we can photograph the injuries that Mr. Perez sustained as well, Judge.
These allegations go way past merely what Mr. Romero advises the court he can afford to pay. His disabilities didn't stop him from allegedly striking this officer's vehicle, not once, but twice. the fleeing that's described here, driving through intersections without any regards for other motorists. If he's willing to go to this extent to avoid apprehension, then really there cannot be much confidence about his future appearance in court. And while he will have a GPS monitor on him, the GPS monitor, what that does, Your Honor, it lets law enforcement know where he is, but it doesn't in any way control what he does or what he chooses to do.
Judge, as you know, there's always two sides to every story, and Mr. Perez has advised me, Judge, he's looking forward to contesting these allegations. One thing he wants to say, Judge, is I believe Mr. Lunder referred to a failure to appear. From what he is telling me, he's never failed to appear in court. He will be coming to court. That's what he wanted me to share with the court at this time, Judge.
All right, thank you both. Ma'am, I just want you to tell me first, are you here just to observe, or is there something that you want to say? Just tell me which one
I
first.
don't know. Kind of both. So I
Okay,
don't know
here's
where-
here's what I'm asking you, because you heard me say this at the beginning, and I tell everyone, everything that we say is being recorded and can be used against him and possibly against you at a later date. Do you understand that? If you wish to say something, then I'm going to swear you in, and then I will allow you to do that. Okay? So you don't want to say anything? Okay, all right, that's fine. All right, the allegations that are included in this probable cause affidavit are obviously very concerning and very serious in nature. When it comes to factors that are considered with regard to bond, the court has to consider a number of things, including whether Mr. Perez will be present for future hearings and whether he is a danger to the community. The allegations that have been presented in the probable cause affidavit give me pause and concern with regard to both of those factors. And so because of that, at this time, I'm going to set the bonds as follows. Count 1, bond will be set at $25,000. Count 2, bond will be set at $1,000. Count 3, the standard bond will remain in place. Count 4, bond will be set at $10,000. The standard bonds will remain in place on counts 5, 6, and 7. If Mr. Perez does post his monetary bond, then he will be placed on pretrial supervision with a level 1 GPS monitor. That means that he will be on house arrest. Additionally, at this time, the court is going to enter an order that Mr. Perez is not to be driving until further order of the court. Mr. Perez, do you understand those conditions?
Yes, ma'am.
Thank you very much.
Thank you.
Thank you. Next will be Ernesto Rodriguez.
He's approaching, Judge. He's here, man. Come on up, sir.
Thank you. Good afternoon, Mr. Rodriguez. Mr. Rodriguez, you are before the court this afternoon on counts 1 and 2 are for fraud, using or possessing identification of another person without consent. Count 3, possession, receiving, retaining stolen credit or debit card. Count 4, possession of methamphetamine. Count 5, possession or use of drug paraphernalia. Count 6, operating without a valid driver's license. Count 7 and 8, possessing a blank, fictitious, or unlawfully issued driver's license. I find probable cause for these charges, and I will hear from the parties.
Judge, in speaking to Mr. Rodriguez, unfortunately, he's not going to be able to afford to post his financial bond. Right now, he's not employed. From what he tells me, he is looking for employment. Now, he lives in Miami with his mom. He's 24 years old, been living in our community for the past 6 years. So, Judge, at this time, he is asking to be released under supervision of pretrial.
Your Honor, my concern is I'm showing he has an open theft and an open trespass in Dade County right now from last year. Yes. He bonded on the theft, and Yes, he's got a $1,000 bond on the trespass. It doesn't show the specific bond amount for the theft.
All right, well, Mr. Romero, based on that, I'm not going to grant the request to release him to pretrial, so do you have another recommendation?
In the alternative, Judge, now he did tell me he was speaking with his girlfriend. He believes that maybe his girlfriend, by asking someone to borrow some money, that she could borrow $300. That would be the premium to go towards the bond with the bondsman. So I'm asking at this time if the court would consider a bond reduction, leave counts 1, 2, and 3 in place, and consider ROR on 4 through 8, Judge.
State, you can respond.
That's that the bond be kept at $5,000. I'd ask for a $4,000 bond, Your Honor.
I will do, I will leave the standard bonds in place on counts 1 through 4. Counts 5 through 8 will be ROR. Jumper,
Mr. Jumper's here, present, Judge, at Maine. I asked him twice, Judge. He declined the service of public defender. He advised me he's going to hire private counsel.
good afternoon, Mr. Jumper.
How you doing, Judge?
I'm good. Mr. Jumper, do you understand that you are entitled to have an attorney represent you for this hearing?
Yes, ma'am.
And you are declining the services of the public defender at this time?
Yes, ma'am.
All right. For the record, you are before the court this afternoon on count 1, possession of weapon or ammunition by a convicted felon. Count 2, tampering with or fabricating physical evidence. Count 3 is a misdemeanor capias that involves a charge for DUI, property damage, or injury. I find probable cause for these charges, and I will first hear from the state.
Your Honor, one, I'm concerned just by the nature of the firearm. This is an AR-15 that Mr. Jumper was in possession of and discarding during a high-speed pursuit where law enforcement was trying to apprehend and stop the vehicle he was a passenger in. As far as I think the court should be aware, the DUI capias, that is from a failure to appear at a VOP hearing. It is the second time Judge Carpenter-Toy has issued a capias in that case. Mr. Jumper's criminal history also includes 2018 possession of firearm by convicted felon. He was sentenced to 364 days in county jail. The case is on probation for possession of cocaine 2016, possession of cocaine 2015, violation of a domestic violence injunction 2015, carrying concealed weapon 05, DUI in 02. Based on his recent prior for the same offense as this, and the other factors I've already mentioned, I'd be requesting a $10,000 bond on count 1.
For the record, I do see that Mr. Jumper is scheduled to go before his division judge to address the capias on Monday morning. Based on the allegations in the probable cause affidavit, I'm going to set bond on count 1 at $10,000. The standard bond will remain in place on count 2. Thank you. Next will be Herguster Mellerson.
He's approaching, Judge. He's here at Maine.
Thank you. Good afternoon, Mr. Mellerson. You're before the court this afternoon on count 1, misrepresenting oneself, committing personal identity fraud. Count 2, second-degree petty theft, first offense. Count 3, fraud, attempting to use identification of another person without consent. Count 4, fraud, uttering a false instrument. Count 5, grand theft, greater than $750, less than $5,000. Count 6, defrauding a financial institution. And count 7 is grand theft, greater than $750, less than $5,000. I find probable cause for these charges, and I will hear from the parties.
Judge, he's not gonna be able to afford the $8,500 bond, which is in place. Now, he is working, he works for Empire Staffing, it's like a labor pool agency, and when there's work, he only gets about $60 to $80 a day. Now, he's been living here in our community his whole entire life, he is 57 years old. He lives in Miami Gardens with his niece. My understanding, Judge, is his niece is the person that's gonna help post his monetary bond. She's working, she works at a local school cafeteria, so, she doesn't make that much, Judge. We were gonna be asking if the court would consider, an ROR on counts 5, 6, and 7, and leave the other standard bonds in place, and he believes that's something that his niece may be able to afford, Judge.
Your Honor, first, I'm gonna be asking that all the bonds be kept in place. I'm also gonna be asking for a GPS monitor, because I think it is necessary that law enforcement is able to keep tabs on his location at this time. Frankly, and I have to assume all the information that Mr. Romero provided is information that was provided to him by Mr. Mellerson. And from what I can tell, I don't know any reason that the court should really put a lot of weight in Mr. Mellerson's credibility at this point in time, based not only on the nature of the allegations that while the state filed the not-in-custody information, essentially alleging multiple instances of identity theft, Your Honor. And then while looking for him to serve the warrant on him, he's arrested, committing another felony level theft with somebody else's driver's license in his possession. Additionally, Your Honor, his history, he's got a federal prior, 2012 possession of firearm by convicted felon. He violated probation in 2017. He's been to, from what getting hits out of California, and most alarming, and I think the reason why GPS monitor is necessary, and while the court should, I don't know that the court could just take Mr. Mellerson's representations at his word. I direct the court's attention to his booking sheet and look at his aliases. Gregory Palmer, Gregory Edwards, Mickey Sunder, Gary Edwards, Greg Saunders, Tony Wright, Jeffrey Edwards. This is an individual that has tried to hide his identity apparently on multiple occasions, and on at least several occasions before the court right now is attempting to use other people's identities to commit theft.
This time I'm going to leave the standard bonds in place. Let's hear Ms. Troutman.
He's approaching, Judge. Mr. Troutman, come on up.
Thank you. Good afternoon, Mr. Troutman.
Hey,
Mr. Troutman, you're before the court this afternoon on count 1, carrying a concealed firearm, count 2, possession of cocaine. I find probable cause, and I'll hear from the parties.
Judge, nothing to add at this time. I'm going to be contacting Mr. Troutman's aunt to post his monetary bond.
I just request an order of no firearms.
All right. Very well. The standard bonds will remain in place. There will also be an order that Mr. Troutman possess no weapons, firearms, or ammunition. If he is in possession of any of those items, he is to surrender them to local law enforcement. Mr. Troutman, do you understand that?
Yes.
Thank you. Oscar Tapia.
He's approaching, Judge Maine.
Thank you. Good afternoon, Mr. Tapia.
Good afternoon, Your Honor.
You are before the court on count 1, burglary with assault or battery. Count 2, robbery by sudden snatching without a firearm or weapon. Count 3, first-degree petty theft, property greater than $100, less than $750. Count 4, resisting an officer obstructing without violence. I find probable cause, and I'll hear from the parties.
Your Honor, and it would appear this is a domestic case in nature. I am going to be requesting a no bond hold on count 1 upon a finding of proof evident or presumption great. I recognize that the victim's mother allowed Mr. Tappy into the house, but as mentioned in the report, when the victim returned home, she wasn't home at the time, but she returned home, became aware of this, she withdrew the invitation, she withdrew the permission for him to be in her residence, and he refused to leave. And as I'm sure the court's familiar, under the burglary statute, that is clearly defined as a burglary once permission is withdrawn and the person refuses to vacate. And then an act of violence was committed. Thereafter, he robbed the victim thereafter. Your Honor, my concern why I think no bond is necessary, this did involve the victim's residence. Mr. Tapia has been arrested for domestic violence in the past. In 2015, he was arrested against a different alleged victim for tampering with the victim and battery. Those charges were dropped. In 2014, he was arrested for burglary of an occupied dwelling, criminal mischief, and violating a restraining order. That was against the same alleged victim as the 2015 case, and those charges were dropped as well.
Judge, I would just ask the court to consider that this is the highest standard, which is greater than beyond a reasonable doubt when we're talking in terms of proof evident presumption great. I'd ask the court not to make a finding of proof evident presumption great based on the probable cause affidavit.
All right, at this time, the court is going to decline to make a preliminary finding of proof evident presumption great. Based on that, I will hear the party's recommendation as to monetary bond and release conditions.
Your Honor, I'm going to be requesting a $20,000 bond on count 1, a $10,000 bond on count 2. And I would also note, and I didn't mention this before, as far as evidence that he committed these offenses in the robbery, when he was giving his statement, he had mentioned that he refused having the victim's property. And then he mentioned specifically, he repeats the phrase, mentioning the specific property that was taken, indicating, providing information that only the person that committed the robbery would know, since it does not make reference that it was discussed prior to that what specific property was taken. I would also be requesting a GPS monitor, considering there is a prior relationship between the parties, also considering the fact that he's been arrested in the past for violating a restraining order.
Mr. Murat, you have to press the button. I can't hear you.
Oh, I'm sorry, Judge. Judge, as you heard, Judge, he's not a convicted felon. Most of the offenses that the state was referring to have dropped, so I believe he basically has a clean record. He's 29 years old, been living in our community for 8 years. He is working. He works for a company called Auto Body Tech. Judge, right now he's living in Fort Lauderdale in a duplex with a roommate. He's been residing there for the past 3 years. His monthly rent is approximately $1,100. My understanding, Judge, he's going to come to court. I mean, he has strong ties to the community. He's been employed with the same company for now 5 years. So, Judge, but unfortunately, he's not going to be able to meet the financial bond which the state has suggested. What I was going to ask the court to consider is a $5,000 bond on count 1, a $2,000 bond on count 2. So we were going to be asking for $7,000 on Mr. Tapia's behalf, Judge.
On count 1, bond's going to be set at $10,000. On count 2, bond will be set at $5,000. The standard bonds will remain in place on counts 3 and 4. If Mr. Tapia does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact that includes a 500-foot stay-away order. Mr. Tapia, so that you understand what that means. No victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
I understand.
Thank you. Next will be to Michael Bolden.
He's approaching, Judge.
Thank you. Mr. Bolden. Mr. Bolden, you are before the court on count 1 as a felony capias. That is a charge for driving while license suspended or revoked. That has a no bond hold. That is not for a magistrate. Count 2 is a misdemeanor capias involving a charge for petty theft. I find probable cause. Do the parties wish to be heard on anything?
Judge, no, I did advise Mr. Bolden that he's going to be going to court on January 27th at 8:30 in the morning, so nothing to add, Judge.
All right, thank you. The bond will remain in place on count 2. All right, that brings us to the end of the first appearance docket. We will go over to the hearing docket now. On page 4 of the felony docket, I have a family member signed in for Matthew Pullins.
Mr. Pullins is here present.
Thank you. Good afternoon, Mr. Pullins. This is a second look hearing. I believe that Mr. Pullins' current bond is set at $2,000.
That is correct, Judge.
I'm sorry? It's $2,100? Okay, my sheet that was sent to me isn't correct then. All right, so it's $2,100 total. All right. Sir, are you're related to Mr. Pullins? Oh, are you just here to observe, or are you here to speak? Okay, all right, he's just here to observe. Okay. All right, I'll hear from the parties.
Judge, I believe that's the gentleman, because when Mr. Matthew was here before you, I didn't request anything. He gave me the phone number of that gentleman to reach out to see if he can post his monetary bond, but I've been unsuccessful. So
Okay.
I wanted to know if he's going to be able to post his monetary bond.
Okay. How is he related to him? He's a little bit hard of hearing me.
I believe they're just friends. They resemble each other. Everyone says that they're brothers, but they're friends. They're good friends.
Partner.
Okay, my bailiff is asking him because he's a little bit hard of hearing. He's saying that he does not have the money.
In that case, Judge, I'm going to be asking if the court would consider releasing Mr. Pullins under pretrial release. I believe he's going to be living in Oakland Park. He's going to be living with Mr. Sansone. He's been here most of his life, Judge, but it seems financially, from what I just heard right now, Mr. Sansone is not going to be able to post his monetary bond.
State.
Well, is he gonna be living? You don't have to speculate. He's the gentleman Mr. Romero's talking about is right here. So,
That's the person Mr. Matthew Pullins advised me he's going to be
All
staying
right.
with.
Mr. Sansone is confirming that he will be residing with him.
Okay. Listen up, the judge is going to give you instructions right now.
Yes, ma'am. Yes, sir.
yeah, they got it.
Just one moment, Mr. Romero. Mr. Linder's just checking something.
I'm a pre-trial with random testing, Judge.
All right. Very well. I will ROR Mr. Pullins to pretrial supervision. He will be subjected to random testing. for drugs and alcohol. Mr. Pullins, that means no alcohol, no intoxicants. Do you understand that, sir?
Yes, yes, ma'am.
Additionally, though you're going to be released today, you're going to get some information from your attorney about pretrial supervision. You must report to pretrial on Monday. If you fail to report to them as instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, thank you very much. I'm just going to go to our misdemeanor docket. Keon Thompson,
I believe Conti.
thank you. Afternoon, Mr. Thompson.
Good afternoon.
All right, state what's going on in Mr. Thompson's case.
Second look, Your Honor. He's county sentenced, frankly. Let me just see if this is in the file. This charge hasn't been filed, frankly. His expected release date on his VOP is April 10th, 2020. It gives, frankly, in his best interest, he has plenty of time in custody to get in front of his assigned judge to even see if we file a charge or not.
Ace, do you have anything you want to add?
I was just looking, I didn't see that you said he's sentenced and being held on something right now.
So pigs.
Yeah, I usually do, I didn't see that, I'm sorry.
County sentence.
Judge, I would tend to agree with that.
All right, so Mr. Thompson, based on the information that's been provided to me, I'm going to take no action at this time. I'm going to leave the bond in place based on what the attorneys are telling me. It seems that it may be in your best interest to leave it as is based on your circumstances.
Yes, ma'am.
All right, good luck.
Thank you.
All right, next will be Roy Miller.
Mr. Miller is approaching, Judge. You hear me? Come on up, Mr. Miller.
Good afternoon, Mr. Miller. All right. Mr. Miller is here on a second look hearing. His bond is currently set at $100. What's going on?
Judge, at this time, speaking Mr. Miller, he wishes to resolve this matter. He wanted to see if the state had a plea offer for him.
I'll offer adjudication time served, but Mr. Miller needs help, and he's just coming in and out, and he's not getting any help. Office adjudication time served?
Oh, time served. Judge, he wishes to accept the state's offer.
All right. Mr. Miller, will you please raise your right hand? Do you swear or affirm to tell the truth? Thank you. You can put your hand down. And Mr. Miller, do you understand everything that we have discussed here today?
Yeah, I think so.
Is anyone forcing you to resolve your case?
Yes, ma'am.
No, is anyone forcing you to resolve your case?
Oh, no.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yeah.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yeah, I've been here
What was that? Can you repeat that?
I've been here all my life.
Okay, all right. Mr. Miller, what plea do you wish to enter? Guilty or no contest?
No contest.
I accept your plea and find that it is freely and voluntarily given. And Mr. Miller, your sentence will be an adjudication time served. Good luck.
Good luck,
Thank
sir.
you.
Venu Devaswamparimbil.
He was released on Wednesday.
He was released on Wednesday, so we're taking him off. All right.
Good job pronouncing the name, Judge. I didn't even try when I was asked by him.
All right, I'm gonna go over to our felony docket. Peter Simone.
No problem, John.
Thank you. Good afternoon, Mr. Simone.
How you doing?
Good, thank you. And Mr. Simone is here on a 30-day motion, is that correct?
That is correct, Judge, and the state has filed the information.
Okay, all right, Mr. Simone, the state has confirmed that they have formally filed these charges, which means that your next step will be to go before your division judge for your arraignment hearing. Good luck to you, sir. Nicole Johnson. All right. Thank you. Good afternoon, Ms. Johnson.
Yes.
Ms. Johnson is here on a 30-day motion. State.
The state has not filed an information at this time. Ms. Johnson is entitled to an ROR in this charge. She's not being held on anything else.
All right. Ms. Johnson, since the state has not yet formally filed this charge against you, you are entitled to an ROR, which means that you will be released today. But I need to advise you that though you're going to be released today, that doesn't mean that that's the end of the case. So it will be your responsibility to keep in contact with your attorneys in the clerk's office so that you know about any future court dates you have to be present for. Do you understand that?
I understand.
All right. Thank you. Good luck, Ms. Johnson.
Thank you.
Corey Williams. Do we know which facility, Mr.
Is
Williams?
it Conti?
Thank you.
It's supposed to be Conti.
Conti, do you have Corey Williams?
Jan, I didn't see him on the docket.
He's on the docket. Are you able to get him for me?
I can't get it. Give me 5 minutes, Jan.
Okay, that's fine. Just let me know when he's ready and I'll go to the next case. Thank you. Carlette Hope.
No problem. Yes, Your Honor.
All right, good afternoon, Mr. Hope.
Your Honor, I'm not
Yes.
quite sure why this motion was even filed. I
Okay.
reviewed it. There was a finding of no probable cause on this charge when Mr. Hope was first arrested, and he was ROR at his first appearance on this charge. It's a moot issue.
It's okay.
Indecent exposure. He's already seen his judge. It's been filed. It's a whole separate matter.
So the motion was filed in error, is what you're telling me?
Yes, I imagine the assistant public defender that filed it didn't realize that he wasn't being held at any point on this charge.
Is there anything else holding him?
Indecent exposure. He's already seen. It's been filed. He's already seen his judge on that.
Okay. All right, well then, in light of that, Ms. Chase, is there anything else that you want to tell me? Okay, all right, then, based on what's going on there, it does appear that the motion was filed in error, so I will deny the motion, since it does appear that Mr. Hope was already ROR'd on this particular charge. All right?
The only request, I'd ask if the court would be inclined to take no action. The only reason being is if someone sees an order declining it, someone may get the impression that the state filed an information for some reason, as opposed to. Yes. No, yes, what happened was I remember this matter. When he was first arrested, he was charged with 2 counts, misdemeanor counts. The arresting officer then charged him with a felony count a day later, a couple days later. While connected to this incident, it got created as a separate felony case number. It's really neither here nor there, because I conceded that the allegations didn't rise to the level of this charge. I suspect it's going to end up being no info. But like I said, the misdemeanor was filed. He's already appeared in front of his judge on that matter.
All right, then that's fine. I'll just take no action with regard to this particular charge at this time. All right? Thank you, Mr. Hope. Good luck.
Yes.
Your Honor, I have Corey Williams.
Okay, perfect. Was that at Conti? Yes. Thank you, Deputy. All right, hi, Mr. Williams.
How you doing, ma'am?
Good, thank you. So Mr. Williams is here on, is this a 30-day motion?
It is, Your Honor. We reset it from yesterday. The state,
Yes.
today is the 33rd day. The state has not filed an information. Mr. Williams is entitled to an ROR on this case. Only thing I would ask, I believe he was ordered not to return to the incident location. I just ask that that remain in effect.
Is there anything else holding him?
Not anymore. This
Okay.
is the last thing.
All right, so Mr. Williams, since they have not yet formally filed this charge, you are entitled to an ROR today, which means that you will be released. I want you to understand a couple of things. Number one, even though you're going to be released ROR today, that doesn't necessarily mean that's the end of the case. That means it will be your responsibility to follow up with your attorneys and the clerk's office so that you know about any future court dates that you have to be present for. Do you understand that?
Yes, ma'am.
Okay, number two, I believe that a no return order was already put in place, but I'm going to remind you once again, there will be an order of no return, which means that you are not to return to the location that this incident allegedly occurred at. Do you understand that?
Yes, ma'am.
Okay, all right, thank you very much. Good luck.
All right, thank you.
We apologize to the Conti, Your Honor.
That's all right. Thank you, Deputy. I appreciate you getting him. Levon Hall.
No problem.
Thank you.
Good morning, Your Honor.
Good afternoon, Mr. Hall. All right,
Mr. Hall's here in a second look. He was placed on a GPS monitor. I would
Yes.
imagine pretrial's not been able to verify any address.
Judge, I was,
Yes.
Judge, I'm assuming he was discharged on the 21st because he was in custody as of the 18th. And speaking to Mr. Hall, that's the only option he wanted to try to get back into that program. He wasn't discharged due to any bad behavior. I'm assuming it's because he was at the program, but I'm assuming it's because he was in custody on the 21st, and that's how they do it. I mean, given the charges here, I'd ask the court to consider ROR, let him go get himself back into the hack, because I do know you have to be out of custody for that.
That's where he was when he got picked up on this new offense. I don't know that just putting him in the same situation is really what's in his best interest if it's turning into a revolving.
And in my review, I'm sorry, go ahead.
If it's turning into a revolving cycle, I think either if you can get on a GPS monitor, great. If not, then his assigned public defender can work with him to find something that's actually going to be helpful. If there's a drug issue, getting him to a treatment center where he can actually get help.
I'd ask the court to just consider the fact it appears to be, my reading of the probable cause was a residue case. It's likely this could end up being filed as a paraphernalia or at the 30-day motion if it's not granted being ROR'd, at least at this point. In the alternative, if Your Honor wouldn't consider ROR or standard pretrial, if we can reinstate his bond at $1,000, let him try to get out. But keeping in mind that it is a residue case.
Actually,
I mean,
the
based on
bag
what I saw.
contained an unused crack pipe with fresh brittle on one end and a fresh crack rock, which did field test positive.
I did not see that. What I saw was the crack pipe, although what I was looking at is kind of written over in marker, so I apologize.
What I think that we should do at this time, obviously he can't be placed on the GPS if the address can't be verified, and he can't verify the address unless he gets out to go there, and that's all dependent on what the homeless task force does anyway, which is out of all of our control. So at this time, I think that we should reinstate Mr. Hall's bond, which will be set at $1,000. And if he's not able to make that bond, then his public defender can address that before the division judge. Thank you, Mr. Hall. Good luck.
Thank you.
Roderick Lockhart. What's up, deputy?
He's not on the docket.
What is going on today?
No, but
We had this problem once before, and I don't know how they rectified it, but
All
we were
right.
getting cases that we wouldn't have on the docket.
Okay, let me hear from what's going on, Mr. Linder.
Deputy, you weren't here yesterday afternoon, were you?
Yes, I was.
Okay, because I thought we were told he was in court,
Right.
so the judge reset him.
Yeah, I remember that.
You guys have to make a note over there, though. Then whoever the assigned deputy is has to make a note if someone's being reset, because sometimes it may not make it on the docket. But you know.
So let me just ask this, deputy. I have one case left. Do you think you can go check and see if you're able to get him for me?
Okay, but that last case is mine.
Okay.
Miller.
Yes, Quentin Miller. All right,
Yes.
let me go ahead and do Quentin Miller. And he bonded? Oh, well then Quentin Miller isn't here anyway.
Here, I have him right here.
He is here? Oh, his bond has been posted? Okay. All right.
He's going to be in the process.
Okay, hi, Mr. Miller.
Hi.
Mr. Miller, you were supposed to be here this afternoon for a second look hearing, but confinement has advised me that your bond has been posted.
Okay.
All right, so good luck to you.
Thank you. God bless.
You're welcome. All right, so let's see what's going on with Roderick Lockhart, and that'll be our last case.
I'm trying to locate him.
Okay, thanks, deputy. Just let me
You
know.
want to, deputy? You want an arrest number, or you got it?
No, I haven't.
Okay.
Yeah. Yes. Didn't put Mr. Lockhart on my docket when they emailed it to me either.
Just Calvin, I'm gonna take these guys back and I'll swing
She's
by and
got this
pick them up.
Lockhart
Thank you.
marked. Do you have something?
About 5-10 minutes.
Okay, I'm gonna go ahead and just put us on a recess. Will you just call and let them know when you're ready for me?
Will do.
Thank
Okay.
you. to Paul Ryan. We have Brianna Lacasse. She was not on my docket for some reason, but we
Okay.
will address
All right,
it.
well, let's see what we got. All
right.
right, thanks. Bye.
This is a second look. All right, hi, Miss Lacasse.
Hi.
All right,
Ma'am.
so Miss Lacasse is here on a second look hearing. She has a $500 bond plus a tab monitor.
It's because, Your Honor was very generous. The state was requesting a bond increase. Your Honor kept the bond in place. Ms. Lacasse was arrested 10 days prior to this arrest for another DUI. And, bonded out $500.
I was advised, and I didn't have an option to speak to her directly, but the deputy said you were going to try to self-bond if you have your debit card in your property.
Yes, it's,
You can speak, Miss Lacasse.
Speak, it's okay, I'm asking you.
oh, okay. Yeah, I have, it should be in my property and I can bond myself out and I will wear the tab monitor.
And you have a valid address?
Yes,
Okay.
I own my own condo.
Do we know, I can't see in Odyssey whether or not that order to access property was done. I don't see it in the,
I honestly don't know, but I will sign
just-
a new one if we need it.
just in case. It
It
was?
done?
I just don't see it updated in Odyssey right now, so.
Confinement is confirming that it was signed.
It was, okay, perfect.
No, it was going for,
Cell
I
phone.
took for a cell phone, not through cell phone.
And the no, it was cell phone and debit card. When we spoke yesterday.
Confinement is advising me that the wording of the order specifically says she would have access to her phone and property so that she could self-bond.
To cell phone, you have to go to main jail.
It's not the cell phone I'm worried about, it's the wallet. I already signed the property order. To self-bond? Oh, they have to send her to main jail?
You have to go to main jail, not from here.
Okay.
Is that something that you're going to be able to accomplish? Do we need a separate order for that?
So deputy, do you need another order for me to be able to have her done? What do
If
you
the
want?
order was done, I can call the main jail and tell them she's cell bound if she's already ready.
So then is she gonna be transferred to Maine so that she can do that?
Yes, I can set that up.
Okay, do you need me to sign an order so that that's clear, or are they good?
No, that's fine. I'll call now. If I have any issue, I'll call you back in a minute.
Okay, thank you.
Okay.
All right, so Ms. Lacasse, you heard all of that. They're gonna go ahead and take care of that. I'm gonna be here for another few minutes because we still have another case to address. So if the deputy finds out there's gonna be an issue and needs another order, they'll let me know so I can sign it, okay?
Okay, thank you.
All right, good luck.
Thank you.
Yes, I can have release it.
Is there anyone else who is somehow on or not on the docket that needs to be addressed besides the last case, which is gonna be Roderick Lockhart?
You gotta be careful with those questions, because someone always finds someone. This is like kind of cameo in a sitcom.
That's the last one that we're waiting on. For, it's S.E. First name is Brianna, Brianna. I know. And the case number that they gave me on there isn't correct, so we gotta find out what the correct number is. All right, so I'm gonna go back off the record for a moment while we're waiting to hear as to whether they can locate Mr. Lockhart. We've got Mr. Lockhart.
Yes. Your Honor, Mr. Lockhart is here on his second look on a felony theft.
Yes.
He has a pending felony theft before Judge Weeks.
Yes.
That's where he was yesterday afternoon
Okay.
for a calendar call. There's been a continuance issued in that case. I actually spoke to the ASA in that case. She has filed a motion to revoke bond in that matter based on this new arrest. That is going to be heard on Tuesday before Judge Weeks, so I would ask the court to take note. He's got a lengthy history in addition to that, but just based on that alone, I would ask the court to leave the bond in place.
What was the current bond in this case?
$750.
Okay. Ms. Chase, you have anything to add? Okay. All right. Based on the information that's been provided, I'm not going to take any action at this time. I will leave the bond as it is, and Mr. Lockhart will see Judge Weeks on Tuesday to address the other issue. All right?
Excuse me, ma'am.
Yes, Mr.
That
Lockhart.
they told me that charge was a misdemeanor, not a felony.
Is there a
Felony theft, so he might have the impression that because it's a petty theft, but it's a felony.
Okay, it's a felony petty theft. If it were a normal petty theft, Mr. Lockhart, it would be a misdemeanor, but because of the way that they have charged, have charged you, it's showing as a felony. It's felony petty theft.
But they said they didn't charge me when I went to court. They said they didn't file charges.
Well, you're going to be, on that case, you're going to be seeing Judge Weeks on Tuesday, so you'll be able to address that issue with her and see what's going on. You can talk to your attorney about it, okay?
All right.
All right, thank you. Good luck.
So you left it as is, $750?
Yes, that's correct.
All right. Man.
All right, thank you. All right, so that brings
Hi,
us...
Your Honor, it's Paul Ryan.
Oh, Paul Ryan. Yes. All
Your
right.
call taken care of. She's getting POT in the main jail.
Thank you very much, Deputy. I appreciate you checking that.
You're welcome. Have a good weekend.
You too. All right, so that brings us to the end of our docket. Everyone have a good weekend.